ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ವಿಧಿಪ್ರಜ್ಞಾ ಕರ್ನಾಟಕ ಕಾನೂನು ಸ್ವಯಂ ಸೇವಾ ಸಂಸ್ಥೆಯಿಂದ ಇವತ್ತಿನ ದಿನದಲ್ಲಿ ನಾವು ಸಿವಿಲ್ ನ್ಯಾಯಾಧೀಶರ ಮುಖ್ಯ ಪರೀಕ್ಷೆಯ ಅಭ್ಯರ್ಥಿಗಳಿಗೋಸ್ಕರ ಒಂದು ಕಾರ್ಯಾಗಾರ ಅಥವಾ ತರಬೇತಿ ಅಂತಲೂ ತಾವು ತಿಳ್ಕೋಬಹುದು. ಇದನ್ನ ನಾವು ಹಮ್ಮಿಕೊಂಡಿದ್ದು. ಇವತ್ತು ನಮ್ಮ ಜೊತೆಗೆ ಚಂದ್ರಶೇಖರಯ್ಯ ಸರು ನಮ್ಮ ಜೊತೆಗಿದ್ದಾರೆ. ಚಂದ್ರಶೇಖರಯ್ಯ ಸರು ಅವರ ಪ್ರತಿಭೆ ಅಥವಾ ಪ್ರೌಢತೆ ಅಥವಾ ಅದ್ರ ಬಗ್ಗೆ ಹೇಳೋದಾದ್ರೆ, ಚಂದ್ರಶೇಖರಯ್ಯ ಸರ್ಗೆ 36 ವರ್ಷ ಅಡ್ವೊಕೇಸಿಯಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇದ್ದು, ನಮ್ಗೆ 36 ವರ್ಷನೂ ಸಹ ತುಂಬಿಲ್ಲ. ಸೊ ಎಷ್ಟೋ ಜನಕ್ಕೆ 36 ವರ್ಷವೂ ಸಹ ತುಂಬಿಲ್ಲ. ಸೊ ಅಂಥದ್ರಲ್ಲಿ ಚಂದ್ರಶೇಖರ ಸರು ಇವತ್ತು 36 ವರ್ಷ ತಮ್ಮ ಒಂದು ಅಡ್ವೊಕೇಸಿಯಲ್ಲಿ, ಈ ಒಂದು ವಕೀಲ ವೃತ್ತಿಯಲ್ಲಿ ತಮ್ಮ ಸೇವೆಯನ್ನ ತೊಡಕೊಂಡಿದ್ದು, ಅವರ ಒಂದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅನ್ನೋದಕ್ಕಿಂತ ನಾವು ಎಕ್ಸ್ಪರ್ಟೈಸ್ ಅಂತ ನಾವು ಹೇಳ್ಬೋದು. ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಂಡ್ ಎಕ್ಸ್ಪರ್ಟೈಸ್. ಸೊ ಅದಕ್ಕೆ ಮತ್ತೆ ಎಕ್ಸಲೆನ್ಸ್ ಅಂತ ಹೇಳಿ, ಆ ಎಕ್ಸಲೆನ್ಸ್ ವಿಚಾರದಲ್ಲಿ ಈ ಒಂದು ನಿಟ್ಟಿನಲ್ಲಿ ಅವರ ಒಂದು ತರಬೇತಿಯನ್ನ ನಮಗೆ ಇವತ್ತು ಕೊಡ್ಲಿಕ್ಕೆ ಬಂದಿದ್ದಾರೆ. ಸೊ ಅವ್ರನ್ನ ನಾವು ತುಂಬ ಹೃದಯದಿಂದ ಬರಮಾಡ್ಕೊಳ್ಳೋಣ. ಶ್ರೀಯುತರು ಚಂದ್ರಶೇಖರಯ್ಯ ಸರ್ ಅವರು ಬೆಂಗಳೂರು ಲಿಟರರಿ ಯೂನಿಯನ್, ಸೊ ಅಲ್ಲಿ ಸಹ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿ ಕೆಲಸವನ್ನ ಮಾಡಿರ್ತಾರೆ. ಅಡ್ವೊಕೇಟ್ ಲಿಟರರಿ ಯೂನಿಯನ್ ಮತ್ತೆ ಲಹರಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಫೋರಂ ಬೆಂಗಳೂರು, ಪ್ರತಿಷ್ಠಿತ ಒಂದು ಅಡ್ವೊಕೇಟ್ ನ ಒಂದು ಅಸೋಸಿಯೇಷನ್ ಆಗಿ ಅಂತ ನಾವು ಹೇಳ್ಬೋದು, ಲಹರಿ ಅಡ್ವೊಕೇಟ್ ಫೋರಂ ಅಂತ ಹೇಳಿ. ಸೊ ಅದ್ರಲ್ಲೂ ಸಹ ಸೆಕ್ರೆಟರಿ ಆಗಿ, ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿ ಸೊ ಇವರು ಕಾರ್ಯನಿರ್ವಹಿಸಿರ್ತಾರೆ. ಮತ್ತು ಟೀಚಿಂಗ್ ಅಲ್ಲಿ ಯಾಕೆ ಚಂದ್ರಶೇಖರ್ ಸರ್ಗೆ ನಾವು ಇವತ್ತು ಬಹಳ ಕೃತಜ್ಞತರಾಗಿರ್ಬೇಕು ಅಂತಂದ್ರೆ, ಚಂದ್ರಶೇಖರಯ್ಯ ಸರ್ ಅವರು ಈಸ್ ಅ ಲಾ ಪ್ರೊಫೆಸರ್ ಸಿನ್ಸ್ 14 years ಆಫ್ ಗೆಸ್ಟ್ ಲೆಕ್ಚರ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸಹ ಅವ್ರಿಗೆ ಇರ್ತದೆ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಸಾಕಷ್ಟು ಲಾ ಕಾಲೇಜಸ್ ಅಲ್ಲಿ ಅವರು ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ ಆಗಿ ಕೆಲಸವನ್ನ ಮಾಡಿ 36 ವರ್ಷ ಒಂದು ಪ್ರಾಕ್ಟೀಸ್ ಅನ್ನ, ಸೇವೆಯನ್ನ ವಕೀಲ ವೃತ್ತಿಯಲ್ಲಿ ಮಾಡಿಕೊಂಡು ಇವತ್ತು ವಕೀಲ ಒಂದು ಬಂಧುಗಳು ಅಂತ ನಾವು ಕರಿಬಹುದು. ಆ ಬಂಧುಗಳು ಮಿತ್ರದಲ್ಲಿ ಒಂದು ಮಿತ್ರ ವೃಂದ. ಸೊ ಆ ಒಂದು ಅಸೋಸಿಯೇಷನ್ ಅಲ್ಲಿ ಇವತ್ತು ಬಹಳ ಹೆಸರಾಂತ ಮತ್ತು ಬಹಳ ಗೌರವವನ್ನ ಪಡೆದುಕೊಂಡಿರ್ತಾರೆ. ಸೊ ಇವತ್ತು Cr.P.C ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ವಿಚಾರವಾಗಿ ಅವರು ತಮ್ಮ ಉಪನ್ಯಾಸವನ್ನ ನೀಡಲಿದ್ದು, ಅವ್ರನ್ನ ನಾವು ತುಂಬ ಹೃದಯದಿಂದ ಬರಮಾಡ್ಕೊಳ್ಳೋಣ. ತಮ್ಮೆಲ್ರಿಗೂ ನಾನು ಬಹಳ ಆಭಾರಿಯಾಗಿರ್ತೀನಿ. ನಾವೊಂದು ಈ ಒಂದು ಅಕಾಡೆಮಿ, ವಿಧಿಪ್ರಜ್ಞಾ ಲಾ ಅಕಾಡೆಮಿ, ಒಂದು ವಿಧಿಪ್ರಜ್ಞಾ ಲಾ ಕಾನೂನು ಸ್ವಯಂ ಸೇವಾ ಸಂಸ್ಥೆ ಅಡಿಯಲ್ಲಿ ಈ ಅಕಾಡೆಮಿಯನ್ನ ನಾವು ಮಾಡಿದ್ದು. ಸಾಕಷ್ಟು ನಾವು ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ಉಚಿತವಾಗಿ ನಾವು ಉಪನ್ಯಾಸಗಳ ತರಬೇತಿಗಳನ್ನ ಕೊಡ್ತಾ ಬರ್ತಾ ಇದ್ದೀವಿ. ಸರಿಸುಮಾರು ಬೆಳಗಿನ ಜಾವ 6 ಗಂಟೆಗೆ ನಾವು ತರಗತಿಗಳನ್ನ ಹಮ್ಮಿಕೊಂಡಿದ್ದು, ಸಾಕಷ್ಟು ಜನ ಬರ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಈ ಕ್ಲಾಸ್ಗಳು ನಡೀತಾ ಇದಾವೆ. ಮತ್ತು ನಮ್ಮ ಉದ್ದೇಶ ಏನು ಅಂತಂದ್ರೆ, ಕಾನೂನನ್ನ ಪ್ರಚಾರವನ್ನ ಮಾಡೋದು, ಕಾನೂನು ಸಾಕ್ಷರತೆಯನ್ನ ಮೂಡಿಸುವಂತದ್ದು ಕೆಲಸ ನಾವು ಸಹ ನಾವು ಮಾಡ್ಕೊಂಡ್ ಬಂದಿರ್ತೀವಿ. ಸೊ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಇವತ್ತಿನ ದಿನ ನಮ್ಮ ಜೊತೆಗೆ ಚಂದ್ರಶೇಖರಯ್ಯ ಸರ್ ಅವರು ಇವತ್ತು ನಮ್ಮ ಜೊತೆಗಿದ್ದಾರೆ. ಸೊ ಅವ್ರನ್ನಾಗೆ ನಾವು ತುಂಬ ಹೃದಯದಿಂದ ಬರಮಾಡ್ಕೊಂತ, ಸರ್ ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್, ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಾವು ಬಂದಿದ್ದೀರಿ. ಈಗ ನಮ್ಗೆಲ್ರಿಗೂ ತಮ್ಮ ಒಂದು ಅನುಭವದ ಅಮೃತವನ್ನ ನಮ್ಗೆ ನೀಡ್ಬೇಕು ಅಂತ ನಾನು ತಮ್ಮಲ್ಲಿ ಪ್ರಾರ್ಥನೆ ಮಾಡ್ಕೊತಾ ಇದ್ದೀನಿ ಸರ್. ಸೊ ನಾನು ತಮಗೆ ಒಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಕ್ವಶನ್ಸ್ ಅನ್ನ ಮತ್ತೆ ತಮಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್ ನಲ್ಲಿ. ಸರ್, ಇಷ್ಟು ವರ್ಷದ ಒಂದು ಕ್ವಶನ್ ಪೇಪರ್ಸ್ ಅಲ್ಲಿ ಇಷ್ಟು ಕೆಲವೊಂದು ಪ್ರಶ್ನೆಗಳು ರಿಪೀಟ್ ಆಗಿರ್ತವೆ. ಈ ಒಂದು ಕ್ವಶನ್ಸ್ ಅಲ್ಲಿ ಆಧಾರದ ಮೇಲೆ ತಮ್ಮ ಒಂದು ಅನಿಸಿಕೆ ಒಂದು ಉಪನ್ಯಾಸನ ಕೊಡಿ ಅಂತ ನಾನು ಕೇಳ್ಕೊಂಡಿರ್ತೀನಿ. ಈ ನಿಟ್ಟಿನಲ್ಲಿ ಅವರು ಬಹಳ ತುಂಬ ಹೃದಯದಿಂದ ಒಪ್ಕೊಂಡು ಇವತ್ತು ನಮ್ಮ ಜೊತೆಗಿದ್ದಾರೆ. ಸೊ ಅವ್ರನ್ನ ಬರ್ಮಾಡ್ಕೊಳ್ಳೋಣ. ಸರ್, ಓವರ್ ಟು ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್ ಸರ್.
Thank you Purushottam sir, you have recognized me and given opportunity to share my thoughts. I am a student still, I have to learn so many things, and I congratulate for doing a human service through this academy. It is my service to your academy also.
Definitely sir, it is our pleasure sir, it is our pleasure, and we are very grateful, and gratitude is there for your service sir.
Please, whatever little I know I can share, and I'm also learning from various quarters. This is one such occasion. Thank you very much for your kind words.
Thank you very much sir. ನಾನು ಈ ಬೆಂಗಳೂರು ಅಕಾಡೆಮಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಅಕಾಡೆಮಿಯಲ್ಲಿ ತಮ್ಮ ಒಂದು ಉಪನ್ಯಾಸವನ್ನ ಕೇಳಿದ್ದೀನಿ ಸರ್. ಬಹಳ ಅದ್ಭುತವಾಗಿ ತಾವು ಟೀಚಿಂಗ್ ಅನ್ನ ಮಾಡ್ತೀರಿ. ತಾವು ಗುರುಗಳಾಗಿ, ಹಿರಿಯರಾಗಿ, ನಮ್ಮಂತ ಕಿರಿಯ ವಕೀಲರುಗಳಿಗೆ ತಾವು ಮಾರ್ಗದರ್ಶನ ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಭಾವಿಸ್ತಾ ಇದ್ದೀನಿ ಸರ್, ಕೇಳ್ಕೊತಾ ಇದ್ದೀನಿ ಸರ್.
Thank you very much. I'm grateful. Shall we begin, sir?
Yes, sir. You can start, sir.
Good evening, friends.
ಅಭ್ಯರ್ಥಿಗಳು ದಯವಿಟ್ಟು ಮ್ಯೂಟ್ ಅನ್ನ ಮಾಡ್ಕೊಳ್ಳಿ, ಅದು ತೊಂದರೆ ಆಗ್ತದೆ ಸರ್ಗೆ ಪಾಠ ಮಾಡ್ಲಿಕ್ಕೆ.
Good evening, friends. Am I audible?
Yes, sir. You are audible, sir.
Thank you, sir. Sir, friends, today the subject assigned to me is insight of Criminal Procedure Code. ಬಹಳ ಮುಖ್ಯ. ನಾನು ಕನ್ನಡ ಮತ್ತು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಎರಡಲ್ಲೂ ಕೂಡ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೀನಿ, ಕಾರಣ ಕನ್ನಡದ ಪ್ರತಿಪಾದನೆ ಬಹಳ ಪ್ರಮುಖವಾಗ್ತದೆ ಬರವಣಿಗೆನಲ್ಲಿ. ಇನ್ಸೈಟ್ ಅಂತಂದ್ರೆ ಈ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೋಡ್, ಈ ದಂಡ ಪ್ರಕ್ರಿಯೆ ಸಂಹಿತೆ ಇದೆಯಲ್ಲ, ಇದರ ಒಳನೋಟ ಅಂತ. ಎಷ್ಟು ಇಂಟೆನ್ಸಿವ್ ಆಗಿ ಹೋಗ್ತೀವಿ ಅಷ್ಟು ನಾವು ಕಲೀಲಿಕ್ಕೆ ಸಾಧ್ಯ. ಬಹುಶಃ ಇವತ್ತಿನ ನನ್ನ ಉಪನ್ಯಾಸದ ಉದ್ದೇಶ ಇಷ್ಟೇನೆ, ಏನಾದ್ರೂ ಒಂದು ಹೊಸ ಪದ, ಒಂದು ಹೊಸ ವ್ಯಾಖ್ಯಾನವನ್ನ ಕೊಟ್ರೆ ಸಾಕು, ಪರ್ಪಸ್ ಸರ್ವಾಗುತ್ತೆ. Because you have heard so many lectures so far, you have read the w.r.t and the procedure code various times. I will also share your thoughts with me in due course of my discussion. I think it is only an interaction of the learning process. Friends, as we know, the Criminal Procedure Code is a mechanism, a machinery, an instrument, a tool to be employed for the purpose of achieving the object. It is aimed at securing justice. This is the preamble of Code of Criminal Procedure. I do not go for the literary meaning of it or the jurisprudence of Criminal Procedure Code. Only I will select few chapters which are very, very relevant for subserving our purpose. And I have selected few sections also here, and I'll correlate with these sections at an appropriate time and will explain. Friends, for the purpose of my discussion, I have arranged the topic. Criminal Procedure Code is a very vast subject which consists of 37 chapters and 484 sections. The best we can do to reach those sections whenever necessity arises. So now I will classify these sections into three parts. One is
Sir, voice is not audible, sir. Voice is not audible, sir.
Not audible, sir.
Voice is not audible, sir. Mostly line cut ಆಗಿದೆ ಅನ್ಸುತ್ತೆ, ಮತ್ತೆ ಜಾಯಿನ್ ಆಗ್ತಾರೆ.
ಸರ್ ಆಯ್ತಾ? ಪ್ರೋಗ್ರೆಸ್ ಆಯ್ತು. Okay.
ಈಗ ಮಾತಾಡಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಇಲ್ಲ ಸರ್, ಸ್ವಲ್ಪ ಸ್ಟ್ರಕ್ ಆಗ್ತಾ ಇದೆ ಅದು.
Sir, can you hear you now, sir?
Yes sir, yes sir.
Okay. Well, friends, ನಾವು ನಾಗರಿಕ ಸಮಾಜದಲ್ಲಿ ಬದುಕ್ತಾ ಇದ್ದಾಗ ಯಾವುದೇ ಒಂದು ವ್ಯವಸ್ಥೆನಲ್ಲಿ ಒಂದು ನ್ಯೂನತೆ ಅಥವಾ ದೋಷ ಅಥವಾ ಆರೋಪ ಅಪರಾಧ ನಡೆದಾಗ what is our duty? That we have to initiate a proceedings. How to initiate a proceedings? You must give that information of the omission or commission of an offense. Therefore, Cr.P.C section 2N of the Criminal Procedure Code defines what is an offense. An offense means any act or omission made punishable under any law for the time in force. So therefore, it is not necessary that a person who has suffered injury shall alone initiate the proceedings. There are two important aspects here. One is an illegality has known to any individual in the society shall set the law into motion. That is a total responsibility of the society at large. The crime is against an individual and against the society at large. Now, when we have the knowledge of an offense being committed, that has to be intimated to the concerned is one aspect. Then an offense has been defined in section 2N. Similarly, we have to correlate with this with that of any law for the time being in force. What is the other laws where the offense being committed? It is a procedural law. Substantive law defines an offense. Section 40 of the Indian Penal Code defines what is an offense. Offense means anything done made punishable under that act. Anything done made punishable under that act. That is the definition given in Indian Penal Code. What is the effect of an offense? An effect of an offense is causing injury. What is injury? Why these are necessary? Because to set the law into motion and to conduct an investigation, inquiry or trial at a later stage, what has been happened is very important. That we must know the substantive law also to set the procedure to be complied, to meet justifiable ends. So therefore, by an act or omission made punishable any other law for the time being in course, that act resulting in an injury. Section 44 of the Indian Penal Code Act defines what is an injury. What is an injury? Injury means an harm. What is harm in Kannada? Hani. See, we know the meaning of word harm in general, but when that's what my object is, to see a few new words introduced is enough for me. Introduction. Harm, hani. To whom? Hani to whom? Injury to whom? To a person. To a person physically, right? Mentally, psychologically, to his reputation, and to the property. This is the widest spectrum of an offense and the consequences of an offense. If this substantive view is understood, all that my endeavor is to see that what to understand and how to understand. If we understood where we have to begin to land somewhere, then we can definitely arrange or organize ourselves to reach that destination. This is my object. Therefore, at the outset, at the beginning itself, we understood procedurally section 2N and substantively section 40 and section 44. Then it is easy for us to make an inroad to see that offender shall be prosecuted and be punished after trial. With this, a substantive issue, let us move on to the next stage. Yes, when an offense is seen or perceived or sustained or suffered, that information has to be given to an authority, be it a police authority or any other authority recognized under law. Then the duty cast on the person who receives such information. Here, a person who has seen or sustained an injury will set the law into motion by bringing that information. Here is called an informant, but not a complainant. I'll explain later stage what is complaint and how the distinction between the information and that of. Yes. When an information is brought to the police officer, whether he has got jurisdiction or not to register a case, this is very, very important. When an information is brought to the notice of an officer concerned, that's a police officer is concerned, whether he has got jurisdiction to investigate or otherwise, shall receive the information. Upon receipt of said information, shall record that information in a case diary maintained by him. And before recording it, every information is not contains an allegation of an offense. This is very, very important. Police officer has a duty, a statutory duty to record it when he must preliminarily satisfy as to the allegation contained in an information discloses a cognizable offense. Then he satisfies subjective satisfaction of an existence of an offense in the allegation, he shall record it. That's what's in Lalita Kumari's case, a very famous full bench judgment. I need not have to read the Lalita Kumar's case in entirety, but that will take the entire time of us. A reference has to be made whenever necessary. You must make a preliminary inquiry to the extent to find out whether that information contains a cognizable offense. If he satisfies that there is an existence of an information of a cognizable offense, he shall record. he shall not refer that person to go to some other police station of which he has no territorial jurisdiction. That amounts to dereliction of duty. There is another Supreme Court has said. Therefore, when the act or the code confers a statutory right on the police officer, he shall record after complying a preliminary inquiry with regard to the existence of an offense in that information. Then the next stage is very, very important. And the information has to be given at the earliest point of time. Why it is necessary? It is for the purpose of taking immediate steps to see that further proceedings to be taken at an earliest point of time. Because there is every chances of memory of a person can be faded. There is every chances of planting an information. There is every chances of manipulating. So therefore, the information must be first in point of time and it should be fresh. Yaake fresh ಆಗಿರುತ್ತೆ ಹೇಳಿ? Information ನಿಜವಾಗಿರ್ತದೆ. Immediately upon the occasion, if an information is brought to the policeman, it's a true anta. In all probabilities, that information is believed to be true. Therefore, it has brought to the notice of the police officer in time. Then the police officer has to register an FIR. FIR ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಬಹಳಷ್ಟು ಸರಿ ನಾನು ನೋಡಿದ್ದೀನಿ. ನಮ್ಮ ಪುರುಷೋತ್ತಮ್ ಸಾಹೇಬ್ ಕೊಟ್ಟಿದ್ರು FIR. What is FIR? What is charge sheet ಅನ್ನೋದ್ರ ಬಗ್ಗೆ? To explain what is FIR. Now I have make this preamble. What is an FIR? It is a duty of the investigating officer to record and to register a case. That is called first information report. Once he record an information in a case diary, as well, he must immediately send an FIR to the nearest magistrate and the superintendent of police for his information and for necessary action in that regard. Yes, next step. Now, first stage is over. That is, initiation of a proceedings upon an information is completed. Then the question of investigation by the police. What is investigation as defined in section 2H of the Act? See, the word investigation is not a narrow campus. It has got an extensive meaning and not an intensive meaning. Investigation means and includes all proceedings under this code for the purpose of collection of an evidence conducted by a police officer or by any other person other than a magistrate who is authorized by magistrate in this behalf. Illi, who has to conduct an information? What purpose he has to conduct an information? See, the purpose of conducting an investigation is to collect the evidence and material. Who has to conduct? Police officer or any other officer authorized under law or authorized magistrate other than the magistrate. Magistrate will not conduct an investigation. He will order the police officer or any other authority to competent to do so to conduct an investigation. And to conduct an investigation is the process of collection of materials insofar as the truthfulness or falsity of the allegations made in the complaint. For the purpose of comprehending collection of the materials in relation to and in connection with the information given to the police officer by way of allegations. This is the meaning of investigation. Investigation contains number of process. It's not a single act. It contains series of activities. So what are all such are some of the activities that an investigating officer can do? Basically, on receipt of an information, an officer shall rush to the spot or chase the information. ಮಾಹಿತಿಯನ್ನ ಬೆನ್ನಟ್ಟಿ ಹೋಗ್ತಕ್ಕಂಥದ್ದು ಪ್ರಪ್ರಥಮ ಹೆಜ್ಜೆ. ಯಾಕಂದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬಗ್ಗೆ ತುಂಬಾ ಸರಿ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ದಾರೆ, ರಿಪೀಟ್ ಆಗಿದೆ. And it is very relevant also for all purposes. See, now we would like to evaluate the steps and the stages of investigation. ಇಲ್ಲಿ ಏನೆಲ್ಲ ನಾವು ಸೇರಿಸಬಹುದು, ಇಲ್ಲಿ ಏನೆಲ್ಲ ಕಲೆ ಹಾಕಬಹುದು, ಕಲ್ತ್ಕೊಳ್ಬಹುದು. ಸ್ಟೆಪ್ಸ್ ಅಂದ್ರೆ ಹೆಜ್ಜೆಗಳು, ಸ್ಟೇಜಸ್ ಅಂದ್ರೆ ಹಂತ ಅಲ್ವೇ? So therefore, the first and immediate and foremost steps is to chase the information. ಆ ಮಾಹಿತಿಯನ್ನ ಬೆನ್ನಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು. ಬೆನ್ನಟ್ಟಿ ಪ್ರಮುಖವಾದ ಪ್ಲೇಸ್ಗೆ ಹೋಗ್ತಾನೆ, ಸ್ಪಾಟ್. The informant may lead the investigation officer to the place of occurrence. Very, very important. A place of occurrence immediate ಹೋಗ್ಬೇಕು. ಕಾರಣ we may find some materials there. And IO can find a person there. IO can find certain materials left by the police officers. Accused. Right? Immediately visit this spot is the first and foremost step of an investigation. Then, when he visits the spot, what can he do further? He can draw the spot mahazar. He can seize the weapons, materials, incriminating documents on the spot and prepare a mahazar for having done this in the spot. It becomes the part of the police report. That's one important step. And the second step is an arrest of an accused. Suppose on the spot, if an accused were present there himself, he can very well arrest the accused at the spot. It would be very convenient and easy for him to proceed further. And you know the process of arrest, I need not say section part 1 to 56. These are all the sections which are not so important for our purpose. The process of arrest as per the amended act has to be complied with. Arrest has to be complied with. Spot alli redundant ag sikkakonbitre ee compliance of the procedure na relax ಮಾಡಬಹುದು. For an offenses which are punishable with above 7 years, arrest is not mandatory in all circumstances. Before arrest, notice to be given and all such other formalities to be complied. But when during the course of investigation at the first stage itself, if he is found to be on the spot, he can very well arrest and take him to the custody, and then he can again conduct a search of a person. A vyaktina search ಮಾಡ್ತಾರೆ. Search mahazar also to be done. ಏನವನಲ್ಲಿ recovery ಮಾಡಲಿಕ್ಕೆ, properties recovery ಮಾಡಲಿಕ್ಕೆ, documents recovery ಮಾಡಲಿಕ್ಕೆ. This is all one such important aspect. Stage ಅಂತ ಹೇಳಿದೆ, steps ಅಂತ ಹೇಳಿದಲ್ವಾ. The next step would be, right, then he has to record the statement of the witnesses.
Lawyer ಪ್ರತಿಭಾದೇವಿ ಯಾರನ್ನು ಹುಡುಕಲು ಮಂಗಳಾಗಿ ಹೇಳುತ್ತಾರೆ. ಸ್ಪರ್ಧೆಯಲ್ಲಿ ಭಾಗವಹಿಸೋಕೆ MGM ಎಂದು ಟೈಪ್ ಮಾಡಿ ಉತ್ತರವನ್ನು 9223170383ಕ್ಕೆ ಕಳಿಸಿ. ರಾಜ ರಾಣಿ ಕಿಚ್ಚಿಗಿಲಿಗಿಲಿ ಮಹಾಮಿತ್ರ.
Can I proceed, sir, Purushottam ji?
So proceed, sir. Proceed.
Yes.
Proceed, sir.
Okay. So then the next stage is issues notice to the witnesses who have an acquaintance with the fact or an incident. That's a further stage of investigation. Section 160. Upon receipt of such notice from the police officer, the person who has the knowledge about that incident shall appear before him in a place where it is shown and to give the true information about the incident which is in his knowledge. Then, Section 161, recording of the statement of the witnesses in the course of investigation. And the statement recorded by the police officer during the course of investigation need not be signed by the maker of it, Section 162. What is the effect? Here we'll have to wait for some time and to move. Then what is the evidentiary value of an FIR and the statement recorded during the course of investigation? It's very important. FIR is not a substantive piece of evidence, but it's a piece of evidence. Whereas the statement recorded by the police officer during course of investigation is a substantive piece of evidence. Then you may ask the question as to when. If the statement of the maker is not, though it is reduced in writing, if the signature of the permission is not taken by the police officer, how to use that statement for the benefit of both parties is the question. What is the evidentiary value of that? It is for the purpose of confrontation and contradiction. Confrontation in a contradiction of the statement made by the witnesses before the investigation officer. It is for that purpose Section 161 statement has to be used. And that the IO has a duty to require the presence of a witnesses in a very legal and sober manner. He must be respected, witness must be respected. And that no inducement, threat or coercion be made to the witnesses during the course of investigation. In the event of such a force or undue influence or coercion is used and the statement is obtained, is not admissible in evidence. Here we'll refer to Section 24, 25, 26 and 27 of the Evidence Act, because Evidence Act is also supplementary or complementary to that of the Criminal Procedure Code. Evidence Act is an adjective procedure. That's how the experience counts, how we have to correlate each other with respect of other sections with that of our subject for discussion. Right? Section 24 mandates that no statement obtained by force, coercion, or undue influence is admissible in evidence. And no extrajudicial confession is admissible, which was obtained in the same manner. And the statement obtained by the police officer when an accused or witnesses, when an accused in his custody is also not admissible. But Section 27 is an exception to that of Section 24, 25. What is Section 27? No doubt, a statement is recorded by the police officer when an accused is in his custody. To the extent of an information given by the accused, insofar as the disclosure and insofar as the discovery of fact is very important. Disclosure statement to first instance and discovery process and recovery processing. Yeno disclosure recovery vyathyasa. Disclose means, yes, in the course of investigation, accused has led the investigation officer to the place where that weapon or a document are kept. That is disclosed. He himself will inform to the officer that this is a place where that he has kept the document or kept the weapon. And recovery process, so very technical, though technical, it is very relevant. Place torsire saldo. You must also show that this is the weapon that he has kept in. Where the place is one thing, and the recovery of that at his instance is the other. So disclosure statement and recovery statement both are very, very relevant for the purpose of the prosecution at a later stage. So these are all steps and stages of the investigation. And yet another important stage is section 164 of the Criminal Procedure Code. This is very, very important. Confession. What is confession? And who has to record that confession? And how it has to be recorded is very, very important. Because on the solitary statement of a conviction, solitary confession, the magistrate or the court can draw a conviction. Therefore, it is a duty of the magistrate at the second stage, and it is a duty of the investigating officer at the first stage, and it is a duty of the accused at the third stage. There are three stages. What is the first stage of an investigation officer? In the course of investigation, if an accused is arrested, he wants or he expresses his intention to make a confession. On such expression of the accused, the police officer shall produce the accused before the nearest magistrate, not the jurisdictional magistrate at all, in all circumstances. He shall be produced before the nearest magistrate, whether he has got jurisdiction to try the offense or not. Then the second stage comes to the magistrate. There are certain precautions to be taken by the magistrate while recording the confession statement. Confession. What are the precautions? The magistrate shall ask the accused or caution the accused. ಇಲ್ಲಿ warning ಅಂತ ಪದ ಉಪಯೋಗಿಸಿರೋವಲ್ಲ. Caution ಆತನಿಗೆ ಎಚ್ಚರಿಕೆ ಕೊಡಬೇಕು. See, you are not bound to make such a statement. You are not bound to make a confession before me. In the event of making such confession that goes against you, and they must ascertain the accused has understood what the magistrate has said, still he desires to make a confession, necessarily he has to record. That record must be in the language known to the accused, or he must explain in the language known to the accused. Then yet another important aspect here is whether, this question is asked a number of times, whether the magistrate can administer oath while recording confession. No, it is not necessary. Magistrate is not recording the administering the oath at the time of recording confession. Why? Administration of oath He is not conducting the trial. He is recording the confession during the course of investigation. In the process of investigation, a confession is made. The law does not mandate to administer him an oath. Afterwards, after having satisfied about himself when the accused is conscious about what he's doing, then he can record under section 281 of Cr.P.C. Any question and answer prakara barkobeku anta heltare. Yes. After recording that confession, he shall read over the contents of the entire confession and take the signature of an accused. And also, the magistrate must sign the confession recorded by him. This is the very important stage of investigation. Then, after this all, now yet another important section is section 167 Cr.P.C. This is a very interesting and elaborate section under the process of investigation. Yes, it's a duty of the police officer if an investigation cannot be completed within 24 hours of his arrest, he shall produce before the magistrate. And upon such production, the magistrate either admit him for the bail, or he may remand to the judicial custody or the police custody, as the case may be. On the request made by the police officer seeking police custody, the magistrate, upon satisfying the requirement of the accused to the custody, if is necessarily required for the personal interrogation for recovery and other things, he may remand to the judicial police custody, or else he will remand to the judicial custody, and maximum period at this stretch magistrate can 15 days. Then, if an investigation cannot be completed within 24 hours, he must produce and take him to custody as the case may be. All right. How long an accused be in judicial custody? And what is the power of a magistrate? Here, there is one technical point we can find in section 167. It is not that the magistrate will remand the accused to the custody. Judicial custody remand anta barela padana. The magistrate will extend the detention. See, when an accused is produced, if he is sent to the judicial custody, that he will be within the jurisdiction of the court, the magistrate. He will extend that period of detention. That is the right word, and not that remanding, extension of remand. Extension of detention by the magistrate. That's one important technical point you must know. Yes. If an offense is punishable with death or imprisonment for life, if the police officer or an authority concerned is not filed the police report, one thing I would like to mention here, the police will not file the charge sheet. The charge sheet has not been defined under the code. They will file the report under police report of section 2R of the Code of Civil Procedure defines proved report or unproved. He will file a police report anta ನಾವು ಕರೆಯಬೇಕು, not the charge sheet. Right. If a police officer failed to submit a report, final report before the after completing the investigation within 90 days, in case an offense punishable with 10 years or death or imprisonment for life, the accused has got a statutory right. This is very important. The default bail another negative word. You can maintain what is statutory bail and the 2020 ಕೊಟ್ಟಿದ್ದಾರೆ. What is statutory bail? Right accrued to an accused to have the bail upon request, and even without a request, a formal application made by the accused before the magistrate can suo moto ask the accused as to whether he is ready to offer surety, and that magistrate is ready to enlarge him on bail. That is called the statutory right conferred on the accused on the default committed by an investigation in case if the authority has not filed a report, police report before the magistrate within 90 days in case of. If an offence is punishable with below 10 years, within 60 days. So therefore, after the period prescribed in section 167, the right to extension of detention has been taken away by the statute. This is what is important, I would like to emphasize. See, extension of detention of an accused is a procedural aspect, the magistrate to exercise. That right will be taken away by the statute on the default committed by the investigating officer. Two things. On the detention and extension of detention and a padavana maintain madi. Police report and a padavana maintain madi, not the charge sheet and not the remand. I think these are the two important issues which I have to share with my experience. Yes. After that, then the question is, of course, there are a number of Supreme Court decisions and High Court decision on the point. What is the date of calculating 60 days or the 90 days or the case may be? Simple issue, you know. It's the date of remand, date of first remanding to the judicial custody, date of production, date of remand, or date of sending to the JC. There are various aspects, right? 60 days or 90 days begins from what date? This is the question. Yes. Yes, friends. Subsequently, after this process, then finally, the investigating officer has completed the investigation and filed a report and section 173 subclass 2 of the Code of Criminal Procedure. That is the final report. The final report. What is final report? One question I have seen. What is final report? What are the materials and contents of the final report? And that you must know. What are all the procedures which we have discussed earlier, right? That is the statement recorded by the investigating officer from the initiation of registration of an FIR, all such proceedings taken from the initiation of the FIR till the completion of the investigation. All documents are to be condensed, compiled, and to be submitted before the magistrate by way of final report. And whether the investigating officer is precluded from further investigation or reinvestigation of the offense. No. At the request or at the order of the magistrate, the police officer can further investigate if some of the materials, objects or materials, documents could not be produced along with the final report. We can very well do that with the consent, with the permission of the magistrate. This is insofar as investigation is concerned. Now, how do you understand the meaning of investigation as defined in section 2H of the Code of Criminal Procedure in your own words? Define madakagutta. I said it is an inclusive definition ಅಂತ ನಾನು ಹೇಳಿದೆ. ಆದ್ರೆ ನಾವು ಒಂದು ಫಾರ್ಮುಲೇಟ್ ಮಾಡಬೇಕಲ್ಲ. No doubt, drawing the sources from the act is one thing, and complementing or contributing our own experiences to that definition to add something is the other. Therefore, with this materials, I have formed the meaning of investigation in my own way. That is, investigation means I have made one investigation is a systematic. You look at the sentence where how we have arrived at. It is a systematic, minute and thorough attempt to learn the facts about something complex or hidden. Beautiful way of presentation is. After having read the commentary, I have come to the conclusion and give my own meaning of the word investigation is. It is a systematic and minute, vyavastitavada, even kshinikavada, then thorough attempt. See the wording language. Thorough attempt to learn the facts. It's a thorough attempt to learn. Is bala mukhya in practice allo aste, in future also for you. A systematic, minute and thorough attempt to learn the facts about something complex and hidden. See, the fact which is complex and the fact which is hidden, that hidden complex fact has to be made, to be searched in a systematic manner. This is called an investigation, as I have contributed to section 2H of the Criminal Procedure Code. Yes, next. The next course is when a report, police report is filed before the magistrate. What next? Now, upon the police report, the magistrate has to take cognizance. Before that, merely filing of a report, it is not, or the magistrate is not bound to accept the report. Necessarily, he did not accept the report. He can return or reject the report filed by the police officer or an authority, as the case may be, under this code. This is one stage of reaching to a stage of cognizance. And secondly, other facet of criminal procedure case is otherwise than on the police report. Eradu now, eradu channel in the material before the court. What is otherwise than on the police report? Take cognizance. I will come section 191B, 12C, explain Martin. Before that, let us collect the materials from other sources in the different facets. What is otherwise than that of police report? It is called private complaint. What is complaint? Section 2D of the Criminal Procedure Code defines complaint. What is complaint? Section 2D now. Complaint means any allegations made before the magistrate by a person against a person known to him or unknown to him, either orally or in writing, with a request to take action against a person for having committed an offense, but does not include a police report. Now, at a relevant point of time, we are discussing, right? Police report allogoitu. Complaint alli police report serporala. Police report is already there before the magistrate upon an investigation on the information. Illi, any person, complaint means any allegation made orally or in writing. You please make it a point. It is not mandatory that a complaint be reduced into writing at all time by all persons. This is very, very important. No doubt certain persons shall make the complaint in writing only. And some person may orally give a complaint to the magistrate alone. Important in classes. Complaint means any allegation. This is bada mukhya. Complaint shall contains an allegation of committing certain offences by a person, whether that person known to him or unknown to him, for having committed some offense. That complaint must be either be oral or in writing, shall be made before the magistrate for taking his action, but does not include a police report. Now you got the distinction between the police report, first information report, FIR, and that of a complaint clear. There is a clarity and there is a distinction. Only informant will give an information to the police officer or the authority concerned. Whereas here, any person, whether it is an injured or not, right, suffered loss or not, made before a magistrate directly, either orally or in writing, which allegations contained an offense, requesting him to take action in accordance with law. And that complaint does not include the police report. In section 2D also, we have seen questions repeatedly. Yes. Now, what is the duty of the magistrate now? When a complaint is given by a third person, what is the action open to the magistrate now? The magistrate either refer that complaint to the police officer for investigation under section 156/3, or he may proceed to record the sworn statement of an complainant and the witnesses present therein and to take cognizance. Now, here is a point where we need to discuss is whether the complaint can be referred without taking cognizance or before taking cognizance, or whether the magistrate can proceed to record the sworn statement after taking cognizance or before taking cognizance. On this issue, there are a number of divergent opinions before the different courts. However, while referring to the magistrate, he need not take cognizance. He need not record the statement and take cognizance. But while issuing process, he must take cognizance and then satisfy himself as to there are certain allegations to be probed, and then to issue process against the accused for his appearance before the court to answer to the charges made against you. This is the complaint process and that of the report process. Now, what is cognizance? Section 191. A cognizance in a pada definition go sikkalla, sikkadu illa, sikku illa. Chapter 14 deals with condition requisite for initiation of proceedings. The magistrate can take cognizance of an offense. See, cognizance will be taken against an offense and not against an offender. That is the law. Under what circumstances the magistrate will take cognizance? Firstly, upon receiving a complaint of facts which constitute such offense. Illi first part kuntala. Upon receipt of a complaint, section 2 denally, that is orally or in writing, right? If that complaint discloses an offense, whether it is cognizable offense or non-cognizable offense makes no difference. See, cognizable illi, what is cognizable and what is non-cognizable offense? Another ill discuss modana, that is relevant because see, cognizable offenses are those offenses the investigating officer has power to investigate without the order of the magistrate. Register the case, investigate, arrest in case of a cognizable offenses. Whereas in case of a non-cognizable offense, the police officer has no right to investigate or arrest or investigate an offender, right? Without the order direction of the magistrate. That's the difference between cognizable and non-cognizable offenses. Yes, now at this stage only, I will draw your attention to section 155, 154 FIR to cognizable case. If a police officer receives an information about the non-cognizable offense in the information, what is the duty of the? This is very, very interesting point. Normally, in Martha police officer, they will take an order from the magistrate to register and to investigate. No, it is not so. Strictly speaking, the true spirit of section 155 is upon such receipt of an information of non-cognizable offense, the police officer shall refer the informant himself to the magistrate, and not that they will obtain the permission from the magistrate and to register and to investigate. That's one important intrinsic value of section 155. The very code itself says that no, it is not that an officer can himself go and get the permission to and then to proceed. He must refer the very informant to the magistrate and to get an order. For instance, section 500 Cr.P.C, IPC in a defamation case, how can a police officer can get permission from the court to register and to investigate? So therefore, the true spirit of section 155 is to refer that informant to the magistrate and to get an order, by a judicial order, to take further steps in the matter. In case where the information contains some of the offenses are cognizable and some of them are non-cognizable. For instance, section 494, section 498A, section 3 and 4 DP Act. In such case, if any one of the offenses is cognizable, the police officers can register and investigate. This is the process and the difference between the cognizable and uncognizable offenses. Right. Now come to the question of cognizance here. What is cognizance? Can it be defined? Illadu definite idu kuda nodi namma CRPC nalli enagide majority of the sections, major offenses has not been defined. ಒಂದು ಡೆಫಿನೆಟ್ ವ್ಯಾಖ್ಯಾನವನ್ನು ಕೊಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯವಾಗದೇ ಇಲ್ಲ. ನಾವೇ ವ್ಯಾಖ್ಯಾನವನ್ನು ಕೊಡ್ಬೇಕು ಅದನ್ನು. ಇವಾಗ ಚಾರ್ಜ್ has not been defined. Cognizance has not been defined. Charge sheet has not been defined. Right, then what is cognizance? Cognizance is an application of judicial mind by the magistrate. And to satisfy himself, first application, then subjective satisfaction of an existence of an offense in the allegations made before him, and then to proceed further. If a magistrate proceeded further, it presupposes the taking cognizance. Application is mind, and to come to the satisfaction that there are grounds to proceed against him, then to pass an order to them, is called cognizance. Yes. Under three circumstances, the magistrate can take cognizance. One is upon receiving a complaint of facts which constitute an offense. Secondly, upon a police report, as we have discussed. And thirdly, upon information received from any person other than a police officer, or upon his own knowledge that such offense has been committed. A, B is very clear. We have discussed at length. And C is upon information received from any person other than a police officer also. Then upon his own knowledge, before the court something has happened, then he can sumo to take cognizance. Adana, upon his own knowledge, he can sumo to take cognizance under section 190. Cognizance beginning of one divsala varsha bekaru madabodu. That is not settled. Only if he proceeded further and he presupposes that he has taken cognizance and applied his mind and taken cognizance. Yes. Next, section 191. It's a very interesting section. Transfer on application of the accused. Whether the accused has a right to get the case before the magistrate to be transferred to some other court. If so, in what circumstances? Under what circumstances? Yes. If a magistrate take cognizance under subclass C of section 190, that is, upon in his own motion, or sumoto if he takes cognizance against an accused, then at the request of the accused, that case may be transferred to some other court. What is the ration behind it? The rationale behind it is a fair trial. The magistrate shall not be prejudiced, or the accused shall not be prejudiced about the fair trial. And circumstances, and section 191, the accused has a right to have this case transferred to some other court if the cognizance is taken under subclass C of section 190 of Criminal Procedure Code. Yes, other things are of not much consequences for us, for our discussion. Now let's go to once if the cognizance is taken and the magistrate will issue notice under section 200 CRPC nalli 200 matte after the charge sheet final report ಎರಡರಲ್ಲೂ ಕೂಡ simultaneously want to avoid the time. We have to discuss within our limited time, so that procedure simultaneously we can save our time. Yes. If the magistrate, upon an information, on a complaint, satisfy himself. If he satisfy himself, he'll proceed. And section 204. After examination of a complaint before the magistrate, if he is satisfied that there is a case made out for trial, he can resort to section 204 CRPC. Tanyathike 203 and 201 and 202 refer madala anta helidre. We are proceeding positively. If he is not satisfied, he will dismiss the case under section 2, complaint under section 203. If he is satisfied only, he will take cognizance and proceed further under section 204. Yes. Then, what is the next stage after issue of process? The accused magistrate may dispense with the personal attendance. While section 204, he will cause a summons to ensure the appearance of an accused before the court. Upon service of the summons, if it does not appear, section 205 only, he can dispense with the personal attendance of the accused for the first time or the second time, as the case may be. It is a discretion. And 206, a permanent exemption, a special summons in case of petty offences. Special summons will be ordered. Then section 207 is a very, very important stage. What section 207 says? Section alley, so many times repeating the questions. What are the rights of an accused upon appearance before the magistrate on receipt of the summons? And what is the duty of the magistrate also? Compliance of section 207 is mandatory. What section 207 say? Supply to the accused copy of police report and other documents. Kindly see here, police report anta heltare vinaha charge sheet anta pada balasalali. Therefore, maintain the police report always. Right? Supply the copy of the police report and other documents anta heltare. Idu mandatory. If you obtain an ex parte temporary injunction under order 39(2), you must comply 39(3) mandatorily, right? To send the copy of the plaint, affidavit and other documents based on which you are claiming your right over. Therefore, whatever the document collected, whatever the materials collected by the investigating officer during the course of investigation, all such copies shall be furnished to the accused at the time of his first appearance before the magistrate, before the trial. Yes. Next. 208. Now, there are two aspects. Magistrate has got the original jurisdiction. Even if an offence punishable under section 302, 307, though he has got jurisdiction to try the case, but the accused will be produced before him and the report shall be produced before the magistrate alone. In case if an offence is exclusively triable of a court of sessions, the police report is filed. Then also you must serve the copies to the accused upon his appearance. The only difference is, in case of a 207 Cr.P.C compliance, he will proceed to try the offence before himself. And insofar as 208, he will supply the materials and invoke section 209. 209. When he found that the offences are exclusive trial by the Court of Sessions, he will commit the case to the Court of Sessions, holding that he has no jurisdiction. Right. So before committal, certain procedure has to be followed. What are those certain procedure magistrate ಮಾಡಬೇಕಾಗಿರೋದು? Either he may remand the accused to the first two complaints, furnishing all the documents. Secondly, in respect of the bail and bonds. If he is already on bail, okay, we'll grant the bail. If he is first time he is appear before the court and the case is exclusively travelled by the Sessions Court, he may remand the accused. Then notify the public prosecutor about the commitment of the case to the Sessions Court. This is section 209 of the Criminal Procedure Code. Then section 210 very sparingly be exercised by the magistrate. Section 210 into the procedure to be followed when there is a complaint case and a police investigation and that for the same offense. When there are two cases, one though on the same set of allegations against the same persons, one the police investigation pending ittade, right? On the same set of allegations, and PCR has been filed and that is pending before the magistrate. Then what is the duty of the magistrate in such a circumstances? Which one of the proceedings to be allowed to continue and which one of them to be stayed or kept in abeyance? And where simultaneously, parallelly, two proceedings cannot be continued. In such circumstances, the magistrate has power. When a case instituted otherwise than in a police report, it is made to appear to the magistrate during the course of the inquiry or trial held by them, that an investigation by the police in progress in relation to the offence, which is the subject matter of the inquiry trial held by him, the magistrate shall stay the proceedings of such inquiry trial and call for report on the matter from the police officer conducting the investigation. Till you sought for the report, right? Parallelly, proceedings agbaradu. Yes, this is insofar as section 210 is concerned. Next. Now I will take you to the very, very important and relevant chapter called the charge. Chapter 16, 17. ಇದನ್ನ ನಾವು ಎಷ್ಟು ದಿವಸ ಡಿಸ್ಕಸ್ ಮಾಡಬಹುದು. ಏನು ಚಾರ್ಜ್ ಅಂದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ? ಚಾರ್ಜ್ ರಿಪೋರ್ಟ್ ಅಂದ್ರೆ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಅಂತಾನೆ. ಇಲ್ಲಿ ದೋಷಾರೋಪಣೆ ಅಂತ ಕರೀತಾರೆ. ದೋಷದ ಆರೋಪ. ಇಲ್ಲಿ ಚಾರ್ಜ್ has not been defined. Kindly take section 2B. ನಿಮ್ಮ ರೆಫರೆನ್ಸ್ಗೆ 2B ಗೆ charge includes any head of charge when the charge contains more heads than one. ಏನ್ ಹಿಂಗಂದ್ರೆ ಏನ್ ಅರ್ಥವಾಗುತ್ತೆ ಇದರಲ್ಲಿ? No. Absolutely it's a practical approach, practical view. ಅಂದ್ರೆ more than one ಇದ್ದಾಗ more than one charge ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. That's a different thing. Right? Includes ಅಂತಾರೆ ವಿನಕ. What is charge ಅಂತ ಎಲ್ಲೂ ಡಿಫೈನ್ ಮಾಡಲಿಲ್ಲ. Then how to assume there is a charge? How to frame the charge? This is a very, very important chapter and it has got elaborate chapter. Adanna onde divasa adane ಮಾಡಬಹುದು. Anyway, for our purpose now, I'll have to give few points on the charge. ಇಲ್ಲಿ ಚಾರ್ಜ್ ಅನ್ನೋದು ಡೆಫಿನೇಷನ್ ಗೆ ಸಿಗದೇ ಇದ್ರು ಕೂಡ ಯಾತಕ್ಕೆ ಡೆಫಿನೇಷನ್ ಸಿಕ್ಕಲ್ಲ ಹೇಳಿ? ಇಟ್ ಕೆನಾಟ್ ಕನ್ಫೈನ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಎ ಚಾರ್ಜ್ ನ ಕನ್ಫೈನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಕಂಡೀಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. It has got an extensive meaning. So instead of defining the charge, section 211 speaks about the contents of charge ಅಂತ ಹೇಳ್ತಾರೆ. ಚಾರ್ಜ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಹೇಳಿದಲೆ ಚಾರ್ಜ್ ಅಲ್ಲಿ ಏನು ಇರಬೇಕು. What is important is that it is not that the definition of a charge makes the purpose be achieved, but what the charge should contain is important. The relevancy of the charge is very, very important. Therefore, section 211 speaks about every charge under this code shall state the offense with which accused is charged. Alway definition ಆಗ್ಬೇಕು ನಮಗೆ. Yes, the charge shall contain offense with which is charged. ಯಾವ ಆರೋಪವನ್ನು ಯಾವ ಅಪರಾಧವನ್ನು ಮಾಡಿದಾನೆ ಅಂತ ಅದನ್ನ ಹೇಳಬೇಕು. Next, if the law which creates the offense gives it in a specific name, the offense may be described in the charge by that name only. ನೋಡಿ ಆರೋಪ ಇದು ಕೂಡ ದೋಷಾರೋಪಣೆ ಅಂತ ಕರೆಯೋದು, ಆರೋಪನೆ ಅಪರಾಧ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ನೇಮ್ ಇರ್ತದೆ. See, he has committed dowry harassment, punishable under section 498A. ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ವರ್ಡ್ ಹೇಳ್ಬೇಕಾಗ್ತದೆ, ಸ್ಪೆಸಿಫಿಕ್ ನೇಮ್ ಆಫ್ ದಿ ಅಫೆನ್ಸ್. ಡೌರಿ ಡಿಮಾಂಡ್, ಡೌರಿ ಹರಾಸ್ಮೆಂಟ್, ರೈಟ್, ಥೆಫ್ಟ್, ರಾಬರಿ, ಆ ಸ್ಪೆಸಿಫಿಕ್ ನೇಮ್ ಹೇಳ್ಬೇಕು. ಇವೆಲ್ಲ ಕಂಟೆಂಟ್ಸ್. Yes. Then, if the law which creates an offense does not give it any specific name, suppose specific name illa anta itkoli, subtle explanation to that has to be given. Narration has to be given. So much of the definition of the offense must be stated. Narration of the offense. A minimum offense, minimum information with regard to the offense has to be disclosed in the charge. Right? ಯಾವ ಅಫೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ಯಾವ ಡೆಸಿಗ್ನೇಷನ್ ಕೊಡ್ತಾರೆ ಅಫೆನ್ಸ್ಗೆ, ಯಾವ ಆಕ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಯಾವ ನೇಮ್ ಅಫೆನ್ಸ್ಗೆ. when there is no specific name, then few contents of the offense, few ingredients of the offense has to be stated. This is very important. The charge is to be framed for the purpose of notifying the accused to prepare himself for his defense or to answer to it, where a fair trial begins from the communication of the charge. So therefore, these are all the material ingredients to be contained and condensed and compiled in the charge to be framed by the magistrate or the court. Then the law and section of the law against which offense is said to have been committed, ಯಾವ ಲಾ ಮತ್ತೆ ಯಾವ ಸೆಕ್ಷನ್ ಅನ್ನೋದನ್ನು ಹೇಳಬೇಕಾಗ್ತದೆ. ಇಂಡಿಯನ್ ಪೆನಲ್ ಕೋಡ್ 498A offense. Then the fact that charge is made is equivalent to a statement of every legal condition required by law to constitute an offense. Charge was fulfilled in a particular case. Charge shall be written in the language of the court. So these are the contents. This takes a lot of time to discuss at length. Yes, contents of the charge. 212 explanation ಕೊಡಬೇಕಾಗ್ತದೆ ಅವನಿಗೆ. ಯಾವಾಗ certain particulars has to be given in the charge. See, at this point of time, at this place, and you, a person, has committed this charges. Particulars, section 212 speaks about the particulars of the charge has to be mentioned in the charge. Then, in what manner you have committed an offense, the manner in which the offense is committed has also been stated. It must be stated at the manner, right? The contents, the particulars, the manner in which offense has been committed and explain. Then 214. Words in charge taken in sense of law under which offense is punishable. In every charge, words used in describing an offense shall be deemed to have been used in the sense attached to them respectively by law, under which such offense is. See, whatever the word that you have used referring to an offense, and that offense must be in relation to the particular penal code. Punitive offense explain madabekku. Then suppose in case of any errors committed in the charge, what is the effect of errors is very, very important also, because unless the charge is properly framed and read out the contents of the charge to the accused, there will be an irregularity in framing of the charge, which may be curable defect. But that has to be rectified at an appropriate time. The error may be committed in framing the charge. The effect of an error has been defined in section 215, which says that no error in stating either the offense or particulars required to be stated in charge, no omission to state the offense or those particulars shall be regarded at any stage of the case as material, unless the accused was in fact misled by such an error, omission to the occasion the failure of justice. Yes. Suppose in case of some error has been committed at the calling, and already I said, error is an irregularity which is a curable defect. The accused cannot take an advantage of that a mistake and error committed in the charge unless that error misled the accused or leading to failure of justice. Yes. Then section 216. You got 216. Alteration of charge. Court may alter any court may alter or add to any charge at any time before judgment is pronounced. This is where the power has been given to the magistrate. Charge some errors in the 215 ali. If an error is manifest, if an error is illegal, that can be cured by the very magistrate subsequently by altering or adding charge at any time before the pronouncement of a judgment. If any such alteration is made or the offense is added, then that has to be notified once again to the accused for an effective trial of the cases. This is the procedure. That's why the procedure is provided to afford an opportunity to the accused to defend him effectively. Yes. When once the charge is altered, then on the altered charge, right, witnesses has to be recalled and to be examined and re-examined for the purpose of, for the benefit of an accused. In the subsequent event, any changes will inure to the benefit of an accused to have his redress his own grievances or to answer to the order charge. Yes, section 2. I'll go a little far, little speed, because of the veracity of the charge is so wide. Then separate charge for distinct offenses. See, in a charge, in a police report, if an accused is charged for many offenses, separate charge, independent and distinct charge should be framed. Then 3 offenses of same kind within a year may be charged together. An identical offense are committed by an accused within a year, same charge can be framed. A trial for more than one offense, section 220. If in one series of acts so connected together as from the same transaction, more offenses than one are committed by the same persons, he may be charged with and tried at one trial for every such offense. A single trial for multiple offenses is permitted under section 220. Yes, 221, where it is doubtful what offense has been committed. If a single act series of acts is of such a nature that it is doubtful which of several offenses the facts which can be proved will constitute, the accused may be charged with having committed all or any of such offenses. A number of such charges may be tried at once. All right. When there is a doubt with regard to the nature of offenses and series of offenses committed by him, all to be tried together. When offense proved included in offense charged, this is very important and interesting. I will tell you why it is important. For the purpose of sentencing, E section is very important. This has to be specifically charged. Sentencing policy, this policy has to be adopted. Yes, I will read this for your purpose. When a person is charged with an offense consisting of several particulars, a combination of some only of which constitute a complete minor offense, and such combination is proved, but the remaining particulars are not proved, he may be convicted of the minor offense, though he is not charged with it. Yes. Minor and major offenses iddaga, minor offense case he may be convicted. When a person is charged with an offense and facts proved which reduced to a minor offense, he may be convicted of the minor offense, although he is not charged with. Minor offense need not be charged, but conviction can be drawn. When a person is charged with an offense, he may be convicted of an attempt to commit such offense, although attempt is not separately charged. Yes, an attempt to commit, though charge is not framed, he may also be convicted for that. Nothing in this section shall be deemed to authorize a conviction of any minor offense where condition requisite for initiation of proceedings in respect of that minor offense has not been satisfied. Yes, now 223. What persons may be charged jointly? Joint trial is permissible? Is a question. Yes, if so, for what sections and overall to be tried jointly? Yes. The following persons may be charged and tried together, namely, persons accused of the same offense committed in the course of the same transaction. Yes, you see, if an offense is committed by more than one person in respect of the same transaction, single trial is enough. He must be jointly tried. Offense is one, and they are standing on the same footing. Why there should be a separate charges and separate trial? There may be difference in ranking extent, but both are standing in the same footing. At that circumstances, joint trial is permissible and recognized. Persons accused of an offense and persons accused of abetment of or attempt to commit such offense. In case of an abetment and attempt, yes, similar to that. So, jointly charged and be tried under section 223. If the offense is identical, if the accused are more than one, whether they have committed or whether abetment to commit such an offense, can be jointly be charged and be tried. Yes. Then 224, withdrawal of remaining charges and conviction on one of several charges, whether it is permissible, whether the other charges can be withdrawn. If so, under what circumstances? Yes. When a charge contains more heads than one is framed against such person, and when conviction has been had on one or more of them, the complainant or the officer conducted the prosecution may, with the consent of the court, withdraw the remaining charge or charges, or the court of its own accord may stay the inquiry into a trial of such charge or charges, and such withdrawal shall have the effect of acquittal on such charge or charges, unless the conviction be set aside, in which case the said court may proceed with the inquiry into a trial of charge or charges so withdrawn. See, what an interesting section this is insofar as framing of the charges. What is the role of a complainant and a court in withdrawing the one charge and permitting the complainant to withdraw the charge? Yes, this section provides the complainant to withdraw the other charge if accused is convicted in one charge, and the court can permit to withdraw other charges also. This is section 223 insofar as framing of the charge. Of course, this chapter requires, in fact, the detailed revisiting for the purpose of elaborate understanding. So this is, in simple terms, I said the contents of the charge. Yes, as the charge has not been defined, we will have to give our own meaning to the charge after our discussion with our experience. Having read section 211 to 224, what we have gathered from our information or discussion, I have given my own meaning to the word charge, though it is not been defined. Yes, no. I formulated my own idea of what is charge is. Charge means and charge is and charge is the precise formulation of the specific acquisition. See, it is a precise formulation of the specific acquisition made against a person who is entitled to know its nature at the earliest stage, right? It is a precise formulation of the specific acquisition. Acquisition must be specific, made against a person who is entitled to know its nature at the earliest stage. It is an acquisition made against a person in respect of an offense alleged to have committed by him. Idine specific acquisition, a precise formulation of a specific acquisition made against a person who is entitled to know at an earliest point of time to make an effective defense for himself is the object of the framing of charge. Yes, friends. Now I will take you to another interesting. Investigation is completed now. Trial begins now. Iga so far idagiddu. When a trial begins, trial to commence only after framing the charge. Then what is trial? Unfortunately, the trial is also not been defined. Then how to mean the trial? We can only mean and understand. That's why in the beginning itself I said, we are here to understand the subject before us by reading, by interacting, by dialoguing in our own way. Then what is trial? When the trial to begin, anadke namge answer ide. Trial to begin only after framing of the charge. Then what is trial anadke namge uttarane ilvalla? Then how to draw the meaning? Where to get the meaning? Only by practice. Right? Trial has no fixed or universal meaning. Then what is trial according to us? It's a hearing a case, right? Civil or criminal, before a judge who has jurisdiction over it, according to the law of the land. ಮತ್ತೆ ಯಾವ ಮೀನಿಂಗ್ ಅನ್ನ ನಾವು ಕಂಡುಕೊಳ್ಬೇಕು, ಇದು ಗೊತ್ತಿಲ್ಲದೆ ಇರತಕ್ಕಂಥದ್ದು ಅಲ್ವಾ, ಗೊತ್ತು ಮಾಡ್ಕೊಳ್ತಕ್ಕಂಥದ್ದೇ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ರೈಟ್, ಒಂದು ವರ್ಡ್ ಬೇಕೇ ಬೇಕು. ವಿ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಎ ಸ್ಪೆಸಿಫಿಕ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆಫ್ ವಾಟ್ ಇಸ್ ಟ್ರಯಲ್. ಏನು ನಮ್ಮ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಅಂತ ಮೀನಿಂಗ್ ಅನ್ನು ನಾವೇ ಕನ್ಸ್ಯೂಮ್ ಮಾಡಿದ್ದು. ವಿ ನೀಡ್ ಟು ಗ್ರಾಬ್, ವಿ ನೀಡ್ ಟು ಅಸ್ಯೂಮ್, we need to exploit, we need to understand, we need to draw the meaning of a trial by the proceedings. This is what not in the, this is not in the definition or the CRPC. CRPC define madilla. We have to redefine for ourselves for an understanding of the meaning of it. ಅರ್ಥವನ್ನು ಮಾಡ್ಕೊಳ್ಳಿ, ವ್ಯಾಖ್ಯಾನ ಬೇಡ, ಅರ್ಥ ಏನಂಗಂದ್ರೆ ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ವರ್ಡ್ ನಾವು ಹೇಳಿದ್ರೆ ನಮಗೆ ಖುಷಿ ಆಗ್ಬೇಕು, ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಬೇಕು. ಆಲ್ ದಟ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಈಸ್ ದಿ ಸ್ಯಾಟಿಸ್ಫ್ಯಾಕ್ಷನ್. ಎ ಟ್ರಯಲ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಮಿ, ಇನ್ ಮೈ ಓನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್, ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ಐ ಆಮ್ ನಾಟ್ ಅನ್ ಅಥಾರಿಟಿ ಲರ್ನಿಂಗ್ ಅಂತ ಹೇಳಿದ್ರೆ, ಎ ಟ್ರಯಲ್ ಈಸ್ ಎ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅಂತ ನಾವು ಹೇಳ್ಬೋದು ಅಲ್ವಾ. ಎ ಟ್ರಯಲ್ ಈಸ್ ಎ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. It shall presupposes the acquittal or the conviction. This is very important. Even the two important issues ತಗೊಂಡ್ರೆ ನಾವು ನಮಗೆ ಟ್ರಯಲ್ ಅಂದ್ರೆ ಏನು ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ಇಟ್ಸ್ ಎ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಒಂದು ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ಆಫ್ ಜುಡಿಷಿಯಲ್ ಪ್ರೊಸೀಡಿಂಗ್ ರಿಸಲ್ಟಿಂಗ್ ಇನ್ ಐದರ್ ಕನ್ವಿಕ್ಷನ್ or an acquittal. So we have come to a concrete conclusion about the meaning of the word trial, though not it is defined. Say judicial proceedings conducted by a court or a magistrate resulting in the acquittal or conviction. That is trial. Now let's go to the meaning of an inquiry. Inquiry in the ಏನು? What is inquiry as defined in section 2G? 2. Inquiry means every inquiry. Inquiry means 2G, yes. Means every inquiry other than a trial conducted under this code by a magistrate or court. ಇಲ್ಲಿ ಕೂಡ how to understand the meaning of inquiry? Who has to conduct an inquiry? Inquiry means every inquiry other than a trial conducted by the magistrate or the court under this code. That is it. Wider spectrum of the definition of inquiry under section 2G. ಇಲ್ಲಿ ಈ ಸೆಕ್ಷನ್ ನಾವು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಕ್ ಹೋದಾಗ ಅಥವಾ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಪ್ರಯತ್ನ ಪಟ್ಟಾಗ ಇಟ್ ಈಸ್ ನಾಟ್ ದಟ್ ಆಲ್ ಎನ್ಕ್ವೈರಿ ಅಂತ ಹೇಳಿಲ್ಲ, ಇಲ್ಲಿ ಎವ್ರಿ ಎನ್ಕ್ವೈರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ರತಿಯೊಂದು ಎನ್ಕ್ವೈರಿನೂ ಕೂಡ. Who will conduct the inquiry? It is not an investigating officer conduct the inquiry. It is a magistrate will conduct the inquiry. It is a court will conduct the inquiry. Under this code, shall we have few instances of such inquiry? For example, idu before a trial could be conducted. Alva. Yav stages ado? Suppose an accused was arrested and brought before the court. right? The magistrate asked him as to whether he was subjected to torture with police. Is an inquiry, isn't it? It's a magistrate or court. And the next issue is in granting a bail, the magistrate will have to satisfy whether he is entitled for bail or not. He will make an inquiry. Then thirdly, a police officer has filed an application seeking an accused to remand him for a police inquiry for interrogation. Then he will inquire as to whether the accused is required for personal interrogation based on the facts and allegation made therein. So these are the every inquiry conducted by other than the trial and tribunal. The scope was given, wide scope was given for the magistrate and court to ascertain. Illi ending enagutte inquiry nalli the result need not be an acquittal or conviction. See about the fact. Existence of the fact are not to be understood or to be ascertained from an inquiry. The truthfulness or the falsehood of a fact has to be ascertained in the process of inquiry, whereas in trial, a judicial proceedings wherein a guilt is proved or not has to be satisfied after trial. These are the two differences between the inquiry and that of the trial. So now the trial and the meaning of trial we have ascertained from the experience we have undergone throughout. Then now I'll take you to the important area where the trial of summons case, warrant case. Which chapter that deals with summons case? Section 251. Section 251 of the Criminal Procedure Code deals with the trial of summons cases. And what are summons case and what are warrants case? Illi definition tagodaga we need not onde kade odkondu hogodagalla. Illi what are summons case and warrant case? Unfortunately, summons case has not been defined. Right? Whereas warrant case has been defined. Summons case, section 2 subclass W of the code says, summons case means a case relating to an offense and not being a warrant case. Hagidana drama of the meaning go. Unless we read what is warrant case, we may not be able to understand the definite meaning of the summons case. Then 10 of section 2 subclass 10 of section X of section 2 speaks about warrant case. Means a case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So the classification of summons and the warrant case has been made based on the quantum of punishment prescribed. Idu artha. Definition bere, adan artha madkolod bere. Right? Summons case are those cases other than the warrant case in Theodore. Whereas in a definition, if a warrant case, there is a clarity. The offenses which are punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So the offenses punishable below 2 years, 2 years, up to 2 years now both for our understanding, or summons case. Then let us go to the mode of trial of summons court and jurisdiction of the magistrate or the court of trial of sessions cases. Summons cases. Section 251 Cr.P.C. 251. Of course, the procedure is very simple because the quantum of punishment prescribed for a trial of summons cases is 2 years and below. And the process is described in chapter 20, commencing from section 251 Cr.P.C, culminate into section 255 of Cr.P.C, resulting in either acquittal or conviction. Section 255 subclass 1 and 5+2. Then what are the process to be undergone from at the time of appearance of an accused till such time of the passing of a judgment of acquittal and or conviction? Yes, when a summons accused is appeared or brought before the court has to ask him whether he pleads guilty or not. The substance of the plea has to be read over, and the magistrate has to ask as to whether the accused will plead guilty or not. In case if an accused admits guilty or pleads guilty, then under section 252, the magistrate shall record the plea. See, this is very important. The plea has to be recorded before passing a judgment. As far as possible, in the words used by the accused, may in his discretion convict him thereon. This is very, very important. See, merely an accused pleads guilty, the magistrate shall not convict him. The duty of the magistrate in case of pleading guilty, he shall record the plea at the first instance and may convict him and may not. This is beneficial proviso available to the accused to have his redress, even in criminal case also. Yes. Then section 253 nalli, conviction on plea of guilt in absence of the accused in petty cases. That, that's why I said it's a summons cases. Plea irtadalli, illi charge irala. The difference between the warrant case and the summons case, the major difference is that in a summons case, in the absence of an accused, an advocate in petty cases can plead guilty on behalf of the accused and pay the fine for his pleading guilty. Right? Upon such pleading guilty, the magistrate may in his discretion convict the accused in his absence. Illi, the very interesting point is whether the discretion can be exercised by the magistrate even in case of conviction. Alva, very, very interesting point. I can understand magistrate can exercise discretion in granting bail or rejecting bail, while in a trial of summons cases, upon pleading guilty by an advocate in the absence of an accused, particularly in a petty cases, the discretion to be exercised by the magistrate in a summons trial, if a party pleads guilty in a petty cases, at his discretion, the magistrate may convict him, sentence him to pay the fine specified in the summons. That is most important. In case of a punishment or a conviction, plead guilty is not permissible. In case of a petty offences, in the absence, at the discretion, the quantum of fine can be imposed by way of penalty that amounts to conviction also. That is the scope of section 253. Then 254, procedure when not convicted, in case he is not pleaded guilty by himself or through his advocate, then the court has to proceed further. See, trial has to commence, trial to begin. Yes. If the magistrate does not convict the accused under section 252 or 253, shall proceed to hear the prosecution and take all such evidence. He has to commence the trial. No? Yes. In support of the prosecutor, also to hear the accused. And then, first he will hear the accused and then issue summons to the witnesses, and all such procedure to be followed, from securing the presence of the accused, examination of the accused, cross-examination of the witnesses and the defense. All such procedures has to be followed. Then, after completion of a due process law in a trial of summons cases, then the magistrate has to pass a final order of acquittal or conviction under section 255. Yes. The magistrate, upon taking the evidence referred to in section 254 and such further evidence, if any, as he may in one motion cause to be produced, finds the accused not guilty, he shall record an order of acquittal. Only if he found that he is not guilty, then he is record an order of acquittal under section 255, exercising the power under section surplus 1 of section 255, acquit, where the magistrate does not proceed in accordance with the provisions section 325 or 360, he shall, if he finds the accused guilty, pass sentence upon him accordingly. Yes, either he has to acquit him or he can convict him. Yes. The next section is section 256. What is the effect of the non-appearance of or death of a complainant, particularly in a summons case? What is the effect if complainant does not present, or if the complainant died? Then the effect would be ಏನಾಗಬಹುದು? Who has to conduct the case? At the first instance, an opportunity will be given by the magistrate by adjourning the case for the appearance of a complainant at the next stage. Right? If not, in the absence of an accused, in the absence of a complainant, or upon the death of the complainant, the magistrate will acquit the accused. That is the scope of section 256. I will read that for your purpose. If the summons has been issued on complaint and on the day appointed for the appearance of the accused or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, notwithstanding anything herein contained, acquit the accused, unless for some reason he thinks fit proper to adjourn. The discretion here for the adjournment, or else we will pass an order of acquittal upon the non-appearance and or the death of the complainant. Then section 257, because the trial of summons case and warrant case is a very, very important chapter and subject for our purpose. ಇದನ್ನು ಯಾತಕ್ಕೆ ನಾನು ಓದಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ, absolutely day in and day out we have to follow these proceedings. be it a lawyer or be it a judicial officer, very carefully has to observe the procedure according to procedure contemplated in someone's trial. Right. Then withdrawal of complaint. Who has to withdraw the complaint and what circumstances and what is the effect of a withdrawal of a complaint? Section 257. Yes. If a complainant,
Pardon, sir?
yes, sir.
Sir, it's almost 9 o'clock, sir, 9 p.m.
Okay.
You started from 7 o'clock. So it's almost 2 hours. It's a continuous marathon.
Yes. So shall I conclude?
Sir, the thing that shall we continue tomorrow, sir, if you won't mind?
Tomorrow I have got some other work.
Okay.
Sunday non fix ಮಾಡಿದೆ ನೋಡಿ ಇದನ್ನ ಇನ್ಸೈಟ್ ಆಫ್ CRPC ಅಂತಾನೆ ಒಂದ್ ದಿವಸಕ್ಕೆ